Hello neighbor, I'm Robert Burns, and in today's Sound Off feature we're going to focus in on the Office of Inspector General within the state of Louisiana. Let me just say this, give you a little bit of background. The Office of Inspector General is set up with the intended purpose of identifying and hopefully collecting back and recovering in the way of fraud, waste, and abuse within state government an amount that would exceed the cost of operating the office itself. Which was during the fiscal 2016 budget. It was around $2 million for rounding purposes. The office did incur about a 15% or so cut for fiscal year 17, leaving it with around a $1.7 million budget. There are 24, give or take, such similar offices in states all across the country, as well as the District of Columbia also has an Office of Inspector General. And in recent years, part of the reason, well, in fact, there was an effort to completely shut down the Inspector General's office this past legislative session. Of course, Mr. Street, the current occupant of the Inspector General's office, went all into a frenzy over that development. You know, in recent times, our current Inspector General has come under quite a bit of heat as a result of some high-profile investigations. But just to give you an example, this is a recent article by the Baton Rouge Business Report. I'll zoom in a little bit closer. You can see Mr. Street's profile there, and it says, "Under Fire." And there have been some recent high-profile cases that have not gone very well for Mr. Street. And in mid-May, he was at the Baton Rouge Press Club in a mad scramble to get the funding restored for the Office of Inspector General. You know, in sharp contrast to the cream puff questions that you often see raised by the mainstream media at the Baton Rouge Press Club, and I don't know any other way to phrase it. I'm sorry, the days of hard journalism have gone out the window. They used to exist, but they don't exist anymore. And so I did pose some questions about these high-profile cases, and we're going to break away and see Mr. Street having an absolute meltdown as I posed those questions of him. So let's break away and see how Inspector General Street reacts to my questioning of some of these high-profile cases. You mentioned lawsuits as an effective means of determining that you were doing a good job. Two of those three lawsuits would be Corey Delahousse and Murphy Painter. In the Delahousse matter, Judge Riggs clearly established that the Inspector General did not follow any of the proper procedures that were required to legally gain the evidence that it had, and she suppressed all of it, and the charges were all dismissed. In the Murphy Painter situation, two of the counts in the indictment involved mailing sympathy cards to associates of his. Judge Brady even openly asked, this rises to the level of a federal offense. What is your argument to some very prominent attorneys that have said that your office it really shouldn't have law enforcement ability, and you've demonstrated that by not following the proper procedures and not performing thorough investigative techniques and proceeding on to trial?
Okay, I was going to say, am I able to repeat that question? And is there even a question there? Let me just say this.
What do you say to those?
I do recognize you, Mr. Burns, and I'm thankful that you brought that question up, because these kinds of questions actually make my case for me. But let me just go forward, and I'll tell you a couple of key facts that Mr. Burns apparently didn't feel were important enough to bring up. In a companion civil case in the federal court in that matter, that individual, whose name I will not mention, was found to be 100% at fault by a federal civil jury. Let me repeat that, 100% at fault in that matter, factually, 100% at fault, and was awarded exactly $0.00 for the, so I'm willing to let that verdict stand for itself. With regard to the indictment that you mentioned, the United States Department of Justice thought enough of the Inspector General's proof in that matter to seek and obtain a 42-count felony indictment. And those of you who are familiar with the federal court process know that those things don't just drop out of the sky. Again, I am willing to accept both the result and the process in that case, and to defend 100% what our office did.
All right, let me pause during that little segment of Mr. Street's meltdown that you can see that he's had when I confronted him with a few of these court cases, and let me respond to the one that he says he won't mention the name of when everybody in the room knows he's referencing Murphy Painter, and I certainly didn't hesitate to mention the name. Now, he is correct. He is 100% correct in that there was a federal jury in which one individual was sued for defamation entailing Mr. Painter, and it is correct that the jury did find Mr. Painter 100% at fault with regard to that incident. I'm very fair in the reporting. He is correct. I can't elaborate on everything he wants to criticize me for and not having brought that fact up. But I will say this: Joe Guyan, who is one of the most respected reporters that I know of, who works within the mainstream media, and I very much look forward to reading articles that he writes. He did cover the appeal of that matter, and as he sought a quote from Al Robert Jr. With regard to that ruling, and I'm going to read the quote that was made. The individual that Mr. Painter had sued actually defended Mr. Painter's suit by arguing that his reputation had already been harmed by the actions of the OIG. The article goes on to say that the state defamation lawsuit continues to this day, and Mr. Street is certainly well aware of that fact. It has been dragging on in Judge Janice Clark's courtroom for over 5 years now. But let me just say this. I went to the entirety of that trial. I attended way more than Mr. Street did, or any people from his office, because they were rarely ever there, except at the end of the day to get little recaps from the U.S. Attorney as to what ought to transpire that day. And each day of it was an absolute unmitigated disaster. Now, why was it a disaster? Well, I had already mentioned in my questioning of him, you bring 2 counts out of a 29, well, what survived as 29 counts. I'm not joking you, accessing a database to get the mailing address to mail sympathy cards to colleagues of his. And you expect to take a federal jury to go into deliberations and to convict him and send him to federal prison for that? And the reality is no. They never had any envisions that Murphy Painter would ever spend any time in federal prison on this. They never envisioned having to try the case. They knew that it was going to cost upwards of $500,000 for Mr. Painter to defend against all this, so they continually went on the premise that he would agree to a plea, all right? Well, Mr. Painter, to his credit, said, oh, no, you're going to bring your case on, okay? And yes, it did cost about $500,000 for his defense. And guess who ended up having to pay that tab? We did. Okay, and that's not to mention what I can guarantee as a former federal fraud investigator myself for 5 years with the federal government, I can guarantee you the federal government's share of the prosecution of that case was well over $1 million. Okay, and I cannot answer his question as to why Walt Green or whomever, Walt Green was in an interim capacity at that point, and I don't know whether Don Kazu made the decision to go forward with this. I would have to assume so. I don't know whether he was fed a dictate that you will go forward with it. All I know is this case was 100% politically motivated because Murphy Painter would not grant a an exclusivity agreement to allow Budweiser to have the exclusive rights to sell alcohol at Saints games in exchange for a $300,000 payment for that exclusivity right. That angered Bobby Jindal, and so basically the ultimatum was given that, hey, get whatever you can on this man, and he was terminated that very day. And by the way, Mr. Painter even said, look, I'll issue the license, but I just want Stephen Waguespack, the Governor Jindal's then executive counsel, to place it in writing that this is what you want. Well, Mr. Waguespack said that was not an efficient use of his time. Translation, I know this is illegal, and I'm not about to put it in writing that it's me responsible. Very smart move on Mr. Waguespack's part, but it shows the utter dictatorship that was the administration of Governor Bobby Jindal. But more importantly, it shows Stephen Street's, I almost said Stephen Waguespack there, Stephen Street's willingness to go in and do his bidding for him. Because let me tell you something, Harry Truman came up with the phrase, hey, the buck stops here. Mr. Street was put on the stand during that Murphy Painter trial. Now this is going to be one of the most high-profile investigations his office has ever done, ever in his career. And he got up on that witness stand and he said, I don't have any knowledge of this case. wow, you don't have any knowledge of this case, and said, you need to speak with my investigator, who happened to be Shane Evans, who was no longer even with the Inspector General's office at the time. Has gone on and still does, to my knowledge, work for the East Baton Rouge Parish Coroner's Office. And Shane Evans, when placed on the stand by Mike Fowler said, these are your notes that say that Mr. Painter was, quote, manic depressive, out of control, and selectively enforcing alcohol statutes, is it not? And Shane Evans said, yes, those are my notes. And then Fowler asked him, well, what investigatory procedures did you use to substantiate these allegations against Mr. Painter? And Shane Evans said under oath, he said, I didn't do any investigative procedures. I just wrote down what he said. He being Brant Thompson, the son of State Senator Francis Thompson, who was appointed interim ATC chief soon after this debacle with Mr. Painter. And so later that evening, as Mike Fowler said, Governor Jindal summoned Murphy Painter into the governor's office, and he fired him. Okay, Shane Evans was asked that on the stand. Mike Fowler said, and it was based on your statements that my client, Mr. Painter, was summoned into the governor's office and terminated. Is that not correct? And Shane Evans said, it's my understanding he resigned. To which Fowler responded, resigned, fired. The bottom line is, my client was out of a job that day, and it was based on your notes without any substantiation whatsoever. So, and I will add that this is a 5-year civil trial that's been going on in Janice Clark's courtroom. When you add in the $500,000 we had to pay for Painter's defense cost, and Mike Fowler and Al Robert, they're his tag team defense attorneys, they earned every dime of it. They did a stellar, and I do mean a stellar, job. And the U.S. attorneys were they mopped the floor with them. I don't know how it took the jury 6 hours to come to this. It was an utterly witch hunt, that was being conducted. Their case was utterly pathetic. In the 5 years I served as a federal fraud investigator, I cannot imagine bringing something this weak. And when a federal judge has to ask you on 2 of those counts, this rises to the level of a federal offense, that ought to tell you something. All right, $500,000 we had to pay for Murphy Painter's defense cost. Who knows what the OIG's investigatory cost pertaining to Murphy Painter was? I can guarantee it was up there. And then we've got all the legal defense costs, having to defend against the lawsuit that Murphy Painter has brought against the state. This thing has been dragging on for 5 years. Preston Castile, this has been a cash cow for him and the firm he's with. There have been 4 amendments to this petition, which continues to be ongoing, and most recently on July 25th, Janice Clark said, and I'm paraphrasing, this is not her exact wording, but she said this case has become so convoluted at this point that she instructed Al Robert to go back. She granted a peremptory exceptions, no cause of action, and asked him to go back and recreate the entire lawsuit in simple, succinct format, because at this point it's become so convoluted with all the defendants that it would be difficult for anyone to try to sit down and figure out what's going on in it. The lawyers that have put in those peremptory exceptions and all that, we're not talking about a couple of nickels here. We're talking about a massive amount of money. And what is my point? If you pull the OIG's organizational chart, you will see the biggest problem that is inherent with it. And while this may not be Stephen Street's fault that the organization chart is what it is, this office reports to the governor. Okay? And you can talk about independence and how you don't have partisan politics. Baloney. Until you have a completely separate, not in any way reporting to the governor, it is a bunch of BS, all right? And we're incurring all of these costs, and they are massive. Make no mistake, they are massive, because Stephen Street has no backbone, and he will march to whatever orders the governor of Louisiana tells him to march to, and that's what happened in the Murphy Painter case. So there's a little background for the benefit of the viewers, to expand upon Mr. Street's quick dismissal of the issue of the Murphy Painter case. Now let's move on to go a little further into his meltdown on my questioning.
I will correct the record, though, on the other matter that you brought up, which is there is no finding that has the effect of law that the Inspector General did anything illegally in any case. Our search warrant authority has been recognized by all judges in the 19th Judicial District Court, including some of the exact same arguments that were made in the case that you mentioned. 19th JDC judges have ruled the exact opposite of those, and the First Circuit actually reversed the judge in that particular case.
All right, now you'll recall earlier that I granted Mr. Street the correctness of his statement that there had been a federal civil jury that did rule Murphy Painter to be 100% at fault. I am going to be a fair blogger in that respect, but I'm also going to be fair in that I'm not going to let Mr. Street get away with what he just said. Now, if you notice, he was very careful in the wording. He said there has been no ruling that has the effect of law that we did anything illegally. Well, he's correct. There was no ruling that had the effect of law, but he's completely inaccurate when he says that the First Circuit overruled or overturned Judge Ricks's decision. And we're going to give you a link to that First Circuit ruling so that you can know how cleverly he's trying to skate this issue. And I'm going to read from it. It says the writ is granted for the sole purpose of remanding the writ to the trial court for a reopened hearing. All right. Basically, the First Circuit Court of Appeals said, hey, look, you're basing all of this motion to suppress based upon the OIG lacking the authority to even go in there and investigate Mr. Delahousse or his business, which I think it was pretty evident they did not. He was an independent contractor. His contractor was not with the state agency. It was with the Livingston Parish. The state tried to argue the fact that, well, the funds flow through Ghost Ship there and flow down to the Livingston Parish, so therefore it is a covered agency. That didn't seem to go over very well in 21st Judicial District Court. And let me read a little further on the ruling. The defendant argued that any and all evidence obtained via the search warrant was obtained, quote, illegally and should be held inadmissible at trial. John McClendon did a fantastic job. That was Corey Delahousse's defense attorney. Everybody else has just kind of been pushovers and said, well, here comes the OIG. Well, they've done this, they've done that. We're not going to question. John McClendon said, oh, wait a minute. And he itemized off the statute, the requirements about a 48-hour period on subpoenas and whether or not they even had search warrant authority at all, okay? And so basically the First Circuit Court of Appeals told them to go back and have another hearing, and I'll read a little bit more, concerning the constitutionality of the search warrant. And only had been addressed so far the Inspector General's right to investigate the defendant and or his business. Accordingly, at the reopened hearing, both parties are encouraged to submit whatever documents and or testimonial evidence that they deem appropriate, and the parties should address the constitutionality of the search warrant. Well, as you well know, if you have an illegal search and seizure, the evidence is going to be suppressed. And Judge Rick suppressed the totality of all of the evidence that was gathered by the Inspector General's office. Now, there was an invitation to, hey, let's have another hearing on all this, and let's talk about the constitutionality. We're in July of 2016. It's safe to say they're not going to have that hearing, okay? This was a year and a half ago. They've thrown in the towel. So yeah, he's a little right that there's been no ruling of law that says we acted illegally. But you know, the old saying, if it looks like a duck, walks like a duck, and quacks like a duck, it's a duck, okay? You recognize the illegality of what you did. You recognize the impossibility of winning your case with all of the evidence being suppressed. And if you felt you had a decent shot of being able to have a favorable hearing on the constitutionality, why in the hell didn't you go ahead and take the First Circuit up on their invitation to have another hearing on it before Judge Riggs? You did so because you knew you were going to lose, and then there would be a ruling of law. So just to clarify that little issue on Mr. Stephen Street's part, you know, and let me just say this, I can see where Stephen Street had his training under the Attorney General's office. As y'all saw, or as my viewers have seen, I did a 5-part series on Judge Buddy Caldwell, and if you take a look at his son, David Caldwell, we did everything right, notwithstanding the outstanding witness tampering pertaining to the CNSI trial. I mean, it was just one debacle after another. And I'm seeing similar refrain with Inspector Street. Oh, well, there's nothing to say we did anything. No thing that has the binding effect of law to say we did anything illegal. The man will not admit that his office is capable of making mistakes, whatever, to be polite, or not engaging in proper investigatory techniques. Now, the point of this all is that the level of sloppiness with the Inspector General's office, and it's been pointed out about not adhering to these statutes and so forth. And I talked about the Murphy Painter trial. I think Al Robert Jr. made what I consider the quote of the entire trial. I've done it on previous videos, but I'm going to do it again. He said, "Your Honor, this is not the FBI. This is the OIG. These people do not know what they're doing," unquote. Now, I'm going to elaborate upon that and talk about the ultimate and sloppy investigative techniques. And I'm going to give you a link for a one-page document. It was a document that Rodney Ramsey, an assistant attorney general with Buddy Caldwell's office, filed into the record. It's dated the 26th of October in 2011. To give you a little bit of background, the former executive director of the Auctioneers Licensing Board had reported two gentlemen engaging in travel voucher frauds. Their names were Buster Gay, the then chairman, and also Ray Camp, a consumer member. She turned all of this into the Inspector General's office, and Greg Lindsay, who was a long-time investigator with the Inspector General's office, going all the way back to the days of Bill Lynch, who was the original Inspector General first appointed when the agency was set up. Greg Lindsay told Ms. Wilkes, and I'm quoting, "We're under the same type of budget constraints as any other state agency. So we're looking for the high-profile cases that will grab us headlines in order to maintain and hopefully increase our funding," unquote. All right. He therefore told Ms. Wilkes that the Inspector General's office would have no interest in pursuing the travel voucher fraud that she had pointed out. Now, that didn't sit well with me as a newly appointed member of the LALB, and I had just been put on by Governor Bobby, "We have zero tolerance for corruption," Jindal. And so I pointed out in an email to his then head of boards and commissions, Ms. Sarah Alcott Allen, that I was not pleased that the Inspector General was just going to ignore this obvious travel voucher fraud, particularly when they had the investigator for the Auctioneers Licensing Board perfectly willing to state that these two gentlemen routinely rode with one another back and forth to Monroe, and yet their travel vouchers showed that they drove separately. Ms. Wilkes contended that had been going on for a number of years, and she had confirmed that it was routine practice by Jim Steele, the investigator, had said, "Oh yeah, I observed them riding together all the time." But why am I bringing that up? They did come in and do a little investigation of the matter, but they were really more so concerned with Reverend Freddie Phillips and whether or not he may have been given some preferential treatment. At least that was the allegation. But going back to the document that was filed into the record by Mr. Rodney Ramsey, it'll see that now Miss Wilkes' successor was a young lady named Sandy Edmonds, and I'm going to read from the 4th line of the document that I'm giving you the link to, and it says, "Miss Edmonds observed a page with notes accidentally left in the file by the Inspector General's office in the investigation of the matter. Miss Edmonds made a copy of the notes, but did not disseminate a copy of the notes to anyone." Well, first of all, that's flat wrong. She may not have disseminated a physical copy of the notes, but I'm here to tell you, and why is this so critical? The work paper that was so carelessly left behind clearly identified the complainant, who was Miss Sherry Wilkes, okay? And I sent an email to Sarah Alcott Allen, absolutely infuriated that the Inspector General was going to ignore this obvious travel voucher fraud, all right? And even more so upset that the identity of a complainant had been compromised through sloppy investigative techniques. Let me tell you something. in the 5 years I was a fraud examiner, if you pull this kind of a stunt, you will be fired, period. Okay? There is no excuse for this kind of sloppiness. Leaving a work paper behind that identifies the identity of the complainant. Well, my little email to Sarah Alcott Allen didn't sit well with Mr. Street, okay? So the next thing you know, he's summoning me into his office, okay? And he's saying my mere reference in that email to Miss Alcott Allen about that work paper could subject me to prosecution. But he would kindly agree not to do so if I issued an email of retraction to Miss Alcott Allen. And I made a decision on the fly. Then I told him, look, no problem, I'll do it, okay? I spoke with Dan Claytor, my senator, afterwards. He's a former assistant DA, Orleans Parish. He said, Robert, he would not be able to get to first base. He said, good luck with that, of his prosecution of me. And I said, look, I am issuing the email retraction because I don't think this guy gives a damn about whether he wins or loses. He is concerned about one thing and one thing only, and that is the funding of that office and having the jobs, all right? That's it, all right? And if Stephen Street had listened to my admonition back then that, hey, you've got some sloppy investigatory techniques going on here. You don't leave a work paper laying around when you go to lunch that identifies the complainant, all right? You don't do it. All right, but oh no, Mr. We do everything right instead of addressing the core problem and thereby helping to alleviate the potential for things like Murphy Painter and Corey Delahousse to flare up. Oh no, he's going to threaten to prosecute me. Okay, instead of addressing the problem, he's going to say, oh, you've let the head of boards and commissions. Now, let me just say this. Sitting across from his office, and Robert Collins held up a laminated copy of this work paper. I wanted to know, is this the work paper? By the way, Miss Edmonds was so proud of herself for having made this personal copy of it that she decided to share a copy with me. She wanted me to see it, and then she immediately took it back, which is fine. I didn't want the thing, but she was really proud of herself and how she could get to the bottom of, what she deemed to be the problems in that office, and that she deemed Sherry Wilkes as the problem in reporting this, all right? And by the way, even this particular court deal that Rodney Ramsey was responding to made very evident that the Legislative Auditor's Office was looking into Miss Edmonds for payroll fraud, okay? But at any rate, he holds the thing at a distance. I said, yeah, that does look like the work paper, and to this day, I'm still glad I made the decision that I did, because in Corey Delahousse's case, we're talking about $58 million of fraud that he served as an FBI whistleblower, and just look what all he got put through, all right? Just look at what all he got put through. And for those of you that are curious as to where that matter stands with his civil trial, it too had a hearing in Judge Mike Caldwell's courtroom on July the 25th, and Judge Caldwell did grant the OIG's motion for peremptory exception of no cause of action, and gave Mr. Delahousse's attorney, Al Robert Jr., 28 days to amend the petition. And while the case is not dead, it certainly may be on life support, simply because I think Mr. Robert and Corey were relying upon the fact that, hey, if you didn't have this jurisdiction, your actions alone of raiding my home, of reading my medical records into the public record, all are defamatory. Because all of that was in the petition, and yet Judge Caldwell made it clear that you're going to have to come up with some actual verbiage that was said by these folks that were defamatory in nature. And in a reply memorandum to the opposition memorandum, one of the attorneys had said, look, you can't just by default say here we are. You bear the burden of proof of stating that we engaged in defamatory, that the OIG engaged in defamatory language, and you're going to have to explicitly so state what that language was. And I'm sure if Mr. Robert files an amended petition, I'm sure there'll be another hearing set for peremptory exception, and it may be difficult to clear that hurdle. Nevertheless, just like with the Murphy Painter, if his case does cease after the next hearing, the litigation expense for that case won't be nearly what it is for Mr. Painter. But I mean, I don't regret my decision, because I can see the way this place operates. And it is that, you know, we're not worried about $58 million worth of fraud, you know, but, you know, we've got an allegation that you had $6,000 worth of billings out of over $2 million in question, that we believe you may not have worked the hours that you worked, you know. And as I said, Greg Lindsay made it clear to Ms. Wilkes, look, we really go after the high profile cases because we have budgetary constraints just like everyone else. Let me give you a little bit more of what Mr. Street had to say, and I'll provide some commentary on that, and we will consider this a wrap. So here's a few more things that Mr. Street had to say during that Baton Rouge press conference appearance.
We are set up to handle the toxic cases that most other public officials will shy away from. And by toxic, I mean, I'm repeating what I told to the face of the members of the Appropriations Committee. Toxic means the cases that are guaranteed to infuriate the folks at the Capitol, and in particular the ones on the budget committees that are going to, and you know, that's just the nature of what we do. We wade into those cases where the politics are already very toxic and very hot and heavy. And our job, as I see it, is to get to the truth and measure it against the law without regard to who it's going to anger, without regard to any political agenda, without regard to partisan politics in any way, shape, or form. That's the only way an office like ours can be trusted.
All right, you just heard what he said. Without regard to politics in any way, shape, or fashion. And I'm here to tell you how he could say that with a straight face, and how any viewer can view that without literally throwing up is beyond me. Because the simple fact of the matter is, Murphy Painter would not go along with breaking the law on a $300,000 exclusivity payment, and Governor Jindal sicked Stephen Street on him, and he went in there with a hapless case that the U.S. Attorney's Office ought to have demonstrated as one of the most colossal embarrassments that's ever been tried in a federal criminal matter. It was an utter embarrassment. Likewise with Corey Delahousse, when you have $58 million in invoices that are denied to contractors because of him reporting fraud and tailing them, you're going to have a lot of angry contractors. We're talking about Livingston Parish that Bobby Jindal carried very heavily. Once again, hey, we're going to find something on this old boy, you know, and the theory has been thrown out that the seizing of his 19 computers was to find out just what all he had. They didn't give a continental damn about the $6,000, you know, of alleged time that he had said that he had worked, which he said he had to camouflage because of constraints he had to meet with FBI informants. But at any rate, you know, I'm just going to say that, look, without regard to politics in any way, shape, or form, as long, I said it earlier, I'll say it again, as long as you are under the office of the governor, and you are, you don't try to spread that line of bull, okay? Because that's what it is. It's complete and utter horse manure, all right? And anybody who believes to the contrary is one of the most gullible folk I would ever know of. And what happens is, when you charge headstrong like that into these type cases, you know, and they backfire, and then we're stuck having to pay these ungodly amount of legal expenses when you understandably get sued by the folk who sue you after them. And so I'm just going to wrap this thing up in saying that Stephen Street's very fond of a little saying, making an analogy about the plug of a boat. And I'm going to read it. This is a verbatim quote of his. You can go to Bass Pro and buy a plug that goes in the bottom of the boat for $10. If you get rid of that plug, you'll save the $10, but eventually you're going to end up with damage to that boat that's exponentially way worse than the $10. Well, I'm going to submit that Mr. Street's oversimplifying things a little bit. You know, I would submit to you, with the sloppiness with which that office operates, he is akin to taking a jackhammer and just slamming holes all through the boat, and the water's coming up through it, and we as taxpayers are having to grab our buckets and try and get the water out of the boat that is emanating from his sloppiness, okay? So it's beyond the $1.7 million a year that his office costs the taxpayers to operate, of which, as I can ascertain, they recover virtually nothing of. They may piggyback off of the legislative auditor and say, oh, we found these wasted travel bookings that were made by state employees on non-refundable tickets that they had to eat. You know, well, that wasn't your work. You know, the legislative auditor did that and you just piggybacked along. And I have found that Mr. Street is very good at piggybacking along. But I would submit the opposite of this $10 plug. We're in here having to bail out water left and right from jackhammer that he's taking because of the sloppiness of that office, as well as the willingness to serve as the lapdog attack for the governor. All right, that is my assessment of the analogy of the $10 plug.
Let me tell you, these attacks on our funding have had a very debilitating effect on our ability to fulfill our statutory mission. And I'll tell you this, since on January 31st, we have 16 positions. An inspector general, an attorney, an admin assistant who kind of runs the day-to-day operations, and everybody else is investigative field personnel. On January 31st, we were fully staffed. Since that time, I've lost 3 employees, including veteran criminal investigators who are not able to withstand the budget instability. It's a problem. It has caused harm to our office in terms of our ability to attract and to retain the type of the qualified individuals that have the combination of skills necessary to work the complex cases that we routinely work.
All right, well, you've seen Mr. Street lamenting about the budget cuts and, oh, how this makes it so difficult to retain qualified folk. You know, well, I would submit to you that the apparent lack of training that takes place in your office to these investigators is far bigger reason as to why they wouldn't stick around, okay? I mean, I have pointed out to you instances of just pure sloppiness. And I'm going to conclude this video, and I mean this sincerely, as one who has dealt with the Inspector General's office and has seen where their priorities are. Just like any other investigatory agency, they rely very heavily on tips from the public, all right? And I'm just going to tell you that based on my experience, based on the experience that Ms. Wilkes encountered, and based on the handling of the Corey Delahousie matter, where they were far more preoccupied in that little $6,000 than they were the $58 million he was reporting. If you've seen governmental waste, fraud, and abuse, I would encourage you to look for an agency like the FBI and look at reporting it. But when it comes to the OIG, I wouldn't walk away, I would run away, all right? And I'm going to tell you right now, it will be a cold day in hell before I ever turn in anything to the Inspector General's office, because I have seen firsthand the way they operate, and my response is no thank you. Thank you so much. All right, now I know what many of you may be saying is that, boy, you sure do like to sound off on public officials, and it seems to always be in a negative light. Well, I am here to tell you our next sound off feature is going to be a very positive sound off feature, giving admiration and praise for a recent ruling made by a state district judge. And that would be none other than State District Judge Don Johnson. And it was made about 6 months ago, but we are going to give you the specifics of it. But I think you're going to very much look forward to hearing that ruling by State District Judge Don Johnson. We look forward to bringing you that sound off feature in the very near future. Thank you so much for your loyalty of tuning into our sound off features, and we hope you have a very enjoyable upcoming Labor Day. Thank you so much.